States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-5030. Ernest F. Mitchell, Lieutenant, Appellant, versus John Phelan, Honorable, in his official capacity as the Secretary of the Navy. Mr. Thayer for the appellant, Mr. Walker for the appellee.
Chief Judge, Your Honors, may it please the court. My name is Dylan Thayer. I am here on behalf of the appellant, Lieutenant Ernest F. Mitchell. Today, Lieutenant Mitchell presents two errors on appeal. First, the BCNR erred in determining that Lieutenant Mitchell was not promoted by operation of law under 10 U.S.C. 624 D5. That statute states, quote, the appointment of an officer may not be delayed for more than 18 months beyond the date on which the officer would have otherwise been appointed. Lieutenant Mitchell's promotion to lieutenant commander was originally scheduled for August 1st, 2020. Lieutenant Mitchell was removed from the promotion list by the secretary in April of 2022. That is a delay of 20 months. That violates the express command of the statute. Now, the secretary stated in his brief that automatic promotion by operation of law is not provided in the statute on its face, and that's true. But Congress has left us a trail of breadcrumbs to follow to indicate that promotion by operation of law is in fact Congress's intent in this circumstance. First, reading 10 U.S.C. 624 D5 out of the statute would clearly violate the rule against surplusage. Second, Congress has legalized appointment by operation of law for senior officers before. Second, 10 U.S.C. 629 C1 and C4 provides for automatic removal only if the officer has failed to secure Senate confirmation. Here, Lieutenant Mitchell was nominated by the president, he was confirmed by the Senate, and then a public act took place, the tolling of the 18-month period under 10 U.S.C. 624 D5. Fourth, 10 U.S.C. 624 D4A makes no sense if officers are not promoted by operation of law. That provision of the statute requires written notice, quote, unless it is impracticable to give such written notice before the effective date of the appointment, in which case written notice shall be given as soon as practicable. If officers are not promoted by the effective date of the appointment by operation of the statute, that makes no sense. There's no danger to be averted there. If, however, officers are in fact promoted by operation of the statute, then there's a concern that notice might not be able to be passed to the officer in time before the promotion takes place.
You're talking about notice of
adverse information that's been discovered against the officer during the promotion process. Now, reviewing the statute, the court in Rollator v. United States in 1999 for the Federal Circuit expressed deep concern that not only could a high-level official like the secretary delay the appointment for longer than 18 months, but that a relatively lowly person in the military hierarchy could delay the appointment longer than the statutory period. It strains credulity, Your Honors, to think that Congress cannot regulate the manner in which the appointment power can take place, but that a relatively low member of a military service branch can. And the Rollator court was extremely concerned about that very circumstance. And reviewing the service branch's interpretation of the statute and reviewing other materials, it concluded that absent presidential action within 18 months, promotion is automatic. Now, the Dysart and Lewis courts in 2004 and 2006 came back and overturned that a few years later, but there was no change in the statutory language, Your Honors. And in fact, the Lewis and Dysart courts conceded that the president's power to appoint under the Constitution can in fact be regulated by Congress. While Congress cannot tell the president to exercise his appointment power, Congress may nonetheless regulate the use of the appointment power. So the Lewis and Dysart courts were correct about that, but they made a category error in finding that this was a requirement to exercise the appointment power, not a regulation of the appointment power. It's well established under the law that presidential inaction can nonetheless be action with the force of law. We see that in the Constitution with pocket vetoes. We see that in 50 USC 622D concerning the lapsing of a national emergency. Congress, pursuant to its power to make rules and regulations for the governing of the land and naval forces, may regulate the president's appointment power in the military sphere. As the Supreme Court has said,
what if Congress passed a law that said president will nominate, recognizes the president will nominate, it recognizes that the Senate will confirm, and it says the president's appointment after confirmation will happen 5 seconds after confirmation. Would that be consistent with the president's constitutional authority to decide whether to appoint someone after confirmation?
yes, Your Honor, I think that would be constitutional. And then there's two reasons. First and foremost, Congress can regulate the appointment power. So actually, I guess there's three reasons, Your Honor. Congress can regulate the appointment power. That's number one. Number two, the president, in fact, has an opportunity in that process to review the qualifications of service members. He has that opportunity during the nomination process. So during the nomination process, a list is reviewed by the service branches through the selection boards. It's sent to the president for approval. So he has that opportunity. And then third, Your Honor, if adverse information is discovered after the promotion is effected, whether the appointment is made 5 seconds after the nomination or whether it's made 18 months by operation of the statute, the president has the opportunity to launch a board of inquiry.
Okay.
Or when the member.
So new hypothetical, the statute says recognizes the president will nominate, recognizes the Senate will confirm, and it says immediately upon the Senate's vote to confirm, the person is appointed. Is that constitutional?
No, I would think not, Your Honor.
Your argument depends on the 5-second difference between the first hypothetical and the second hypothetical?
I think there has to be Marbury versus Madison said there has to be a moment in time when the appointment power ceases. So there has to be some sort of cleavage between the nomination process and the appointment process. Now, I think if Congress wanted to set that at 5 seconds, I think Congress would be able to do that pursuant to its ability to regulate the use of the appointment power. And as I mentioned, the president would not be left without remedy if after
1 second.
I think there has to be a split, Your Honor. Clearly, it's a 3-step process under the Constitution, under the Supreme Court's holding in Marbury versus Madison.
And you were saying the president would not be without remedy. You said the president can launch a board of inquiry. I mean, the president has removal power, no?
Yes, but there are due process concerns with exercising that removal power in an arbitrary and capricious manner. So there has to be some sort of process afforded to the service member, but also the president can do a grade determination when the member is being retired. So if the appointment power is exercised and the president later decides or discovers information such that the member is not fit to hold his particular grade, the president does have options. And so I think that issue that Your Honor.
I just don't see how the appointment power is being exercised in either of two scenarios. One is the hypotheticals that I've been giving you, but another is our case where the appointment will happen automatically, at least absent a statute that very expressly states that the appointment will happen on day 181 if the president hasn't acted first. I think arguably you would have a better argument there that the president is on sufficient notice to know that his silence for 180 days will be the choice to appoint. But as you began your argument, at best, we've got some breadcrumbs here, not an express notice to the president that this is how you will exercise your appointment power.
It's true, Your Honor. That's not expressly delineated in the statute. It's not expressly delineated in the statute what happens to the officer after those 18 months. But Congress's command is clear. You cannot have the officer in the delay status for 18 months.
But is it clear? I mean, in the delay status and then potentially the confirmation expires because so Section 624D does sometimes make clear what should happen after a delay. If an officer is criminally charged and then acquitted, the officer has to be retained on the promotion list. And the statute doesn't specify what should happen if an officer is convicted. But I think on your theory, given that there's a 90-day deadline for taking action in that situation, the convicted officer would get an automatic promotion while the acquitted officer just goes back onto the list. And that seems like an intent that we would not reasonably ascribe to Congress. And if that's true, then why wouldn't a parallel reading be applicable here?
I think you could ask the question another way, Your Honor, right? I mean, if the officer has been convicted and the president knows he's been convicted, why wouldn't the officer then be removed from the list? So I think that, Congress is clearly putting the onus on the president here and on the executive branch to act. This court has previously ruled.
The president is busy, 90 days. It's involved in other emergencies. A recommendation goes to him. Nobody acts on it. Really, that convicted officer is going to be automatically appointed?
The president is certainly busy, Your Honor, but he has many people working for him. He has the Secretary of the Navy, he has the Navy's lower level officers and functionaries. I think that this court has held and I see my time is up, so if I can just finish my answer to Your Honor's question. This court held in White v. Secretary of the Army that when the service branch makes errors, the onus is on the service branch to repair the errors, not the service member, because the service branch is better positioned to repair those errors than the service member. So in Your Honor's hypothetical, I think the onus is still on the service branch.
There are two bases in the record, as far as I know, for the detachment for cause. Is it correct that either one is sufficient to uphold the Secretary's determination?
Yes, Your Honor. He could be detached for cause under either 1611-0203B or 3C, but he did not satisfy the regulatory language of either provision, Your Honor.
And you say that the period of time here was too short to show substandard performance over, quote, an extended period of time.
That's correct, Your Honor.
Are there any instances where a military body or a court has concluded that some period of time is too short to meet that standard?
I'm not aware of any instances in which they've concluded that it's too short, because the military usually wants to give itself as much leeway as possible. I am aware of other instances in which they have found that provision to be met. I believe those are included in our brief. One in Magnuson v. Mabus, that was 11 months. Another was 7 months. And in another scenario, the member who was detached for cause had 3 adverse fit reps, one of which was, I believe the language the court used was overwhelmingly negative. Lieutenant Mitchell did not have any adverse fit reps. So those scenarios are much more acute than the scenario Lieutenant Mitchell was in, Your Honor. And it's similar for the detachment for cause under 3B. That regulation requires gross negligence or complete disregard of duty. And if you look at the cases in our brief, Your Honor, Lieutenant Mitchell's misconduct clearly does not rise to that level.
And you do, I think, a good job of saying that the records in those cases are more serious, but it still leaves you having to, make new ground in terms of this being not an extended period. And you characterize Mitchell's poor performance as beginning with the letter of instruction, but doesn't the letter itself document some amount of poor performance preceding it?
Certainly, Your Honor. And I think there's a fine distinction here. And I welcome the opportunity to elucidate our thinking here to the court. We certainly don't deny, we cannot deny, this is the way time works. When the letter is given to Lieutenant Mitchell, obviously the incidents happened before what's contained in the letter. However, receiving a letter of instruction is a discrete event in the military. So prior to receipt of that letter of instruction, Lieutenant Mitchell's misconduct did not rise to the level where his superior officers considered it necessary to give him such a letter of instruction. So that's the distinction. It's not that we're saying that there's no misconduct prior to that date. We're saying at that date, his misconduct was considered significant enough adverse enough that he was given this letter, which is a specific and discrete event within the standpoint of military administrative
So
discipline.
you're saying you can make a kind of limited inference about how poor the performance was preceding that because it was only then when it kicked up.
That's right, Your Honor. It's like if you give, a child warnings about certain behavior and then, only at that point that they've done it a certain number of times, you put them in timeout. Like, what was there misconduct prior to the letter? Of course, but only at that date did it rise to the level that his superiors felt the need to act.
One clarification question. I'm going to ask the government about a part of their argument where they say it wasn't necessary to even show gross negligence or complete disregard of duty. All that needed to be shown was misconduct. Do you have what's your response to that?
Yes, that's a good question, Your Honor. So I covered that in my brief, in our brief. The government has forfeited that argument because it didn't present that argument in the district court, first of all. Second of all, the BCNR itself did not find that any misconduct could have satisfied Milper's ban 1611-020. It didn't evaluate it under the framework of 3A. If you look at the language that the correction board used, and that's what we're reviewing today is the correction board's decision, they evaluated it under the framework of 3B and 3C. I would also posit finally that it's a hallmark of statutory and regulatory law that regulations are not to be interpreted in a rigidly literal fashion. So if you look at the rest of the regulation for information about what misconduct satisfies detachment for cause, it says detachment for cause is one of the most serious measures that can be taken against an officer and should only be this is a quote, only be undertaken with full appreciation of its gravity. So that suggests that when it says any misconduct that it's backing away from that a little bit. It also says that only that if disciplinary action has not been taken against the member for the misconduct that forms the basis for the detachment for cause, the command must expressly indicate why. So there's clear limitations in the regulation itself.
Okay.
In addition to the fact that argument is forfeited by the government.
Anything else?
Oh,
Thank you.
Thank you.
We have from Mr. Walker.
Thank you, Your Honor. May it please the court, Johnny Walker for the Secretary of the Navy. My friend has identified two issues for the court. The first, their contention that Lieutenant Mitchell was promoted by operation of law. The second, that the board's decision to maintain the detachment for cause in his records was arbitrary and capricious. I think that there is a clear and narrow path to affirmance on both of those issues, and I would like to address those with the court. On the first, their contention that Mr. Mitchell was promoted by operation of law, the simple matter is that the law provides no such operation. The law provides the outer limit for a delay, which is 18 months. We were over that 18 months here, but the remedy that they seek is nowhere found in the law, and I think my friend just acknowledged that here at the podium today. The law on its face nowhere provides for an automatic promotion. So what that leads to is essentially an application of the canon of the omitted case, where Congress has not provided for a particular remedy. It's not up to a court to craft that remedy as a matter of statutory interpretation. So we think that is easily resolved. My friend argues.
Is there any remedy?
There could be, as we note in our brief, there could be, they could demand immediate action on the delay, but that delay can end in one of two ways, right? It doesn't necessarily end in a promotion. It could end in the gentleman being removed from the promotion.
You mean they could go to court and ask a court to demand action?
They would have to go through their inter-service remedies first. They could go to the board for the correction of naval records and seek appropriate remedy there. And if they didn't obtain it there, they could go to a court.
So they'd go to the board for correction of naval records during the period of delay, or could he still do that and say, this was unlawful delay, I didn't get a decision in time?
I believe there's a number of remedies they could go through. They could, go to their direct commander and say, I've been waiting too long. I need an action on my complaint. But I mean, the cause of the delay.
But not after the period has closed.
After the 18 months has elapsed.
They could do that.
Yes, I think so. I mean, at that point, the military would be in violation of the statute, and to come out of violation of the statute, it would have to make a determination on the delay or end the delay.
What if on day 181, every person in the entire executive branch who is approached by Lieutenant Mitchell to make this happen soon says, we're just going to delay. You're going to get no relief from us. So, don't hold your breath. What does he have does he have any remedy outside of the executive branch?
He might, once he exhausts his remedies, he might go to court for a mandamus. But I mean, the violation there is the overlong delay. But there is nothing, but what he is arguing here is not just, is that the statute itself provides this automatic remedy of a promotion, and that's nowhere in the statute.
What about his response to my last question, which was really me kind of parroting your argument that the standard, this is now issue 2, not issue 1, the standard should be misconduct, not gross negligence or complete disregard of duty. And you heard his answer both on the forfeiture point and on the merits point. What's your response?
Well, getting to my clear and narrow path for affirmance on the arbitrary and capricious point, I think it is this point about misconduct. Misconduct and not gross negligence was the basis for the commander's request for detachment. He mentioned nowhere in that request for detachment gross misconduct. He said, I request to detach Lieutenant Mitchell on the basis of misconduct and on poor performance of duty over an extended period of time. And it's not true that the board looked at this from a gross misconduct standpoint only. It addressed that when responding to Mr. Mitchell's or Lieutenant Mitchell's arguments, which again mischaracterized the basis for the commander's request for detachment. But it also said on the very first page of the board's analysis that it was looking at this from a misconduct basis and that, quote, the misconduct was severe enough to justify all the penalties here. In the district court, the government did not address this from a misconduct perspective. We did not make the argument that this could be affirmed solely based on misconduct, but that is in part, again, because the counts in the complaint were 2 on the arbitrary and capricious point. There was one count that the standard did not meet gross misconduct, which, as I said, never applied to the disciplinary action in the first place. And the second was that the conduct or the performance, there was no poor performance over an extended period of time. So the government addressed the case as they framed it, though it was misframed from the way that the record frames it.
So it's your position that the list doesn't expire after the period of after it exceeds the permissible delay. It just is a prompt. The government is supposed to act. And as you say, possibly it could be a jumping off point for mandamus or seeking some other attention within the executive branch or the like. But it's your position that Lieutenant Mitchell still could be appointed.
I'm sorry, that Lieutenant Mitchell
could be appointed. That the nomination and confirmation by the Senate remain operative.
Oh, yes. I don't think that there's an automatic consequence one way or the other when the delay expires. There's no automatic promotion. There's no automatic denial of a promotion in perpetuity. It's just that the promotion is continuing to be delayed by the Navy longer than the statute provides, but that's what it is doing. Again, the sort of three-part or 3-step exercise of appointment laid out in Marbury versus Madison, I think serves both a functional purpose here as well as sort of a constitutional purpose. Constitutionally, there's a question as whether or not the Congress even could do this, but functionally, we know that it just couldn't happen like that. There is no mechanism for an automatic appointment by operation of law because there has to be that positive act that Marbury versus Madison talks about to effectuate the appointment.
If Congress clearly said, and they should drop off the list after this period of time, or the list should evaporate after the executive hasn't acted, is that impermissible intrusion on the executive's appointment power? I know it's not something we have to decide. I'm just interested.
It may be because there you're barring the executive from taking an action. And I will note that the statute not only does not provide for.
This is more about the facts of the case, and this is a question from someone who hasn't served in the Navy. Can you give us a sense of how minor or how major leaving the ship for maybe as little as 15 minutes and stopping McDonald's on the way for a friend who's hungry is?
I think when you put the additional perspective on it, this wasn't just an individual leaving a ship, and it wasn't necessarily just 15 minutes. Lieutenant Mitchell's characterization of the amount of time it was off the ship has changed from somewhere under an hour, quote, to 15 to 20 minutes. But it wasn't just that he left the ship. He was the command duty officer in charge of the ship, and the ship was leaving port the next day. There were significant preparations underway, and as his commander, the commander of the Howard says, there were a number of things that could have gone wrong. And you or I, as civilians, may characterize this one way or the other, but I put a lot of stock in the fact that Mr. Mitchell's commander on the Howard said that this was serious and egregious misconduct, that the brigadier general, who was the commander over Strike Group 11, of which the Howard was a part, said this was serious and egregious conduct. The chief of naval operations said the same. The secretary said the same. And the board for the correction of naval records agreed with all of them. So I do think this is very serious conduct. As the board found, every senior leader of the Navy who examined the discipline that was imposed on Lieutenant Mitchell found it to be perfectly appropriate. And I think deferring to them, as this court's precedents require, this is far from arbitrary and capricious action by the board.
Thank you.
Thank you. Please affirm.
And did Mr. Thayer reserve rebuttal time?
2 minutes.
You don't have to take it, but you may.
I would like to, Your Honor. Thank you so much. I want to address first what my friend across the aisle said about the second issue, the under Milford's-Man 1611. He has admitted, the government has admitted, Your Honors, that this is forfeited. It was not addressed in the district court. The issue of whether or not any misconduct could form the basis for detachment was not addressed by the government for the district court. They may try to pin that on Lieutenant Mitchell, but the government has provided no reason why this court can review it now. And under this court's case law, the default rule is no review on appeal for issues forfeited in the district court. You're also, Your Honors, not required to defer to the correction board in this instance to the heightened degree normally required for military personnel decisions. This is a review of a regulation. This court is perfectly free to employ normal, arbitrary, and capricious review to determine whether or not Lieutenant Mitchell's misconduct met the requirements of gross negligence or complete disregard of duty or substandard performance over an extended period of time. It did not. Now, turning to what my friend across the aisle said about 10 U.S.C. 624 D5, he essentially said 10 U.S.C. 624 D5 can operate and nothing happens. That violates the rule against surplusage, Your Honors, clearly. As a point of order, Lieutenant Mitchell did demand action. He did go to his leadership. He did ask for a decision. And this remedy that the secretary crafts where someone can go and demand action or someone can file a mandamus action, that's not in the statute either. So there's no indication in the statute on its face as to what happens in this instance. We're left with looking at the clues that Congress has given us. And the clues that Congress has given us very strongly indicate that at the end of the 18-month period, an officer is promoted by operation of law. Thank you.
Thank you. Case is submitted.
Case number 24-7140. Jannease Johnson versus District of Columbia et al. Appellants. Ms. Anderson for the appellants, Mr. Hannan for the appellee.
Good morning, Your Honors. Stacey Anderson on behalf of appellants Quincy Booth and Wanda Patton. With the court's permission, I'd like to reserve 2 minutes for rebuttal. Your Honors, I think where I want to begin today is with the second prong of the qualified immunity analysis. The jurisdictional question and the merits on that point are clear-cut and straightforward. This court plainly has jurisdiction to consider whether the law was clearly established at the time Ms. Johnson was removed from her position. In Johnson, the court recognized it's a reviewable determination. It's a question of law, and it's one where the court assumes, reviewing the question, that the facts are taken in the light most favorable to Ms. Johnson. And the district is not disputing that that is the appropriate standard here. We review the facts in the light most favorable to Ms. Johnson.
One of the things we have to decide is whether the April 27th interview, which I guess then aired in early May, was a but-for cause of the firing. That seems like a pretty fact-bound question.
Yes, Your Honor. But again, on the clearly established prong, the court assumes there was a constitutional violation. The court would resolve that
Right,
question.
which is why what's presented to us regarding the April 27th interview seems like it may not be the type of question we have jurisdiction to consider on an interlocutory appeal, because it is not raising any disputed questions of law. It's just raising a disputed question of fact.
As to the disputed question of fact, Your Honor, I think there is an area where the court has jurisdiction, and that's where the factual finding or the lack of a factual finding here would not be supported by the record, is blatantly contradicted by the record. So in the district's view, the record would blatantly contradict any finding that Patton knew about the April 27th interview.
I thought that was exactly the part of it that Johnson versus Jones said is not subject to scrutiny. It is generally a question of law. To be sure, we review summary judgment on final judgment all the time. And it's a legal question whether the record reflects a material issue of fact and dispute such that the non-moving party, if it's the plaintiff, could persuade a fact finder. But Johnson versus Jones does something different in terms of.
I don't dispute that, Your
Okay.
Honor. I think Scott
But it
versus.
seems like you are fighting the record in terms of.
Again, let me make clear, for purposes of whether the law was clearly established, we resolved that factual dispute in Ms. Johnson's favor. We will take that the court can assume that Patton knew about the interview. The question on the clearly established prong is whether, assuming that constitutional violation exists, whether the law was clearly established that terminating Ms. Johnson in the circumstances of this case was unconstitutional.
Now,
And-
am I understanding you right? You are assuming, for the sake of argument, that the April 27th interview was a but-for cause of Johnson's firing?
For purposes of the second prong, I'm not conceding that point. If the court gets to the First Amendment question, I am not conceding that point. I would argue that, again, based on Scott versus Harris, where facts are blatantly contradicted by the record, and in this case, it's our view, the court does have jurisdiction. It's a narrow exception. I recognize Johnson versus Jones. I understand that principle, but it is a narrow exception.
If nothing had been written, said, or leaked other than the April 27th interview, would Johnson have been fired?
If nothing else, I don't believe so, Your Honor. I think that the department's clear that her statements to the media had nothing to do with her termination.
So, I think the record supports you on that. I think arguably it would be a blatant misreading of the record to conclude otherwise. But that question of whether the record supports you on that is outcome determinative in my hypothetical. And we have to just, I'm asking you, is that a question of fact that we don't have jurisdiction on interlocutory appeal to consider?
You have jurisdiction, Your Honor, again, because I believe it is blatantly contradicted by the record under Scott versus Harris. That's a very narrow exception.
Yeah, but
this is not about.
Since you have a videotape and nothing to the contrary. We have nothing close to that here.
I disagree, Your Honor. We only have two pieces of evidence in the record regarding Patton's knowledge. One is her statement that she knew nothing about the interview. And the second is a email received the day after the interview, April 28th, that said Ms. Johnson's going to be interviewed at some point in the future. No rational trier of fact can find from that gave Patton notice that Johnson had been interviewed the day before.
No, but the termination takes place sometime after that. There's a hearing officer who says termination is not appropriate here. All the facts, including the email facts, only support lesser, a reprimand or some kind of discipline. And the decision makers here pushed for further consideration. And so that's part of what the district court is taking into account, is that there's a kind of a re-decision on discharge. And there's no dispute that that's with knowledge of the interview.
No, I believe that they didn't learn about her participation in the interview until this litigation, Your Honor. So that is disputed. But I do want to talk about the hearing examiner's recommendation for just a moment. I give that very, very little weight, and I think the court should give it very little weight because she did not understand the Whistleblower Protection Act. She believed that Ms. Johnson was a whistleblower, and yet she recommended that Ms. Johnson be reprimanded or suspended. That is illegal under our Whistleblower Protection Act. If in fact Ms. Johnson was a whistleblower, we could take no retaliatory action against her. We could take no adverse employment action. That hearing examiner fundamentally misunderstood our Whistleblower Protection Act. So that recommendation was just based on a misunderstanding of the law. But again, if I could just briefly get back to my point on the second prong, whether the law was clearly established. The court does not need to look at the facts in this case on a granular level to look at that. I think there are only really two main facts that warrant consideration on the second prong. And that's the fact that Ms. Johnson was a correctional or law enforcement officer. And that fact's important because in the analysis, the government gets a little bit more deference in that context. And the second fact is that she disclosed confidential information. Those two facts alone, looking for clearly established law, just taking those facts, Ms. Johnson hasn't identified a single case where a court in this country has found a First Amendment violation with respect to a law enforcement officer who has disclosed confidential information. There is not clearly established law that would suggest that it's a First Amendment violation to terminate her in those circumstances. In contrast, the district has identified authority from this court, Bauman and Braderman, where the court found no First Amendment violation where law enforcement officers disclosed confidential information. And the district has cited cases from other jurisdictions where there's been no First Amendment violation. There was no decision out there that would have put Booth and Patton on notice in this case that in firing Johnson as a correctional officer who disclosed confidential information would violate the Constitution. I think the court can render that decision and that would be dispositive here.
Do you know how other HIPAA violations have been handled by the Department of Corrections?
I don't know that there have been others. I know in this case there was, I think, one email disclosed by the union president that may have contained information. I don't think the OC was aware of that at the time. They haven't taken any corrective action since. But the point here, I think—
Is the union president a DOC employee?
He is. But the point I want to make, Your Honor, is even if he were offered up as a comparator, which Ms. Johnson has not done, the degree of her egregious violations of the HIPAA statute, I think, make her not comparable to him. So, and Patton was very clear that in her over 20 years in the DOC, she had never seen such an egregious violation of the district's confidentiality provisions.
But this is unlike Bauman in the sense that in Bauman, there was an investigation going on into, I think it was like a hostage taking situation. It was quite a serious situation that was separate from any investigation into Bauman's conduct. And there we also held that it was only for the period of time that it would have been serious that it was serious to disclose the recording. And here we don't have any actual investigation that suffered
Again,
Johnson's disclosure.
And I don't think the district had to show an investigation. I think the Supreme Court was clear in Connick and this court was clear in LaFond that we only have to have a reasonable basis to believe that there may have been some impairment of the investigation. And we did at the time. I mean, you look at the time frame, that incident notification email went out at 8:45 in the morning. 30 minutes later, it was sent to the union attorney, and then that afternoon sent to a reporter. That day is when DOC began its investigation of the leak. That's when we learned about that, right? And so in that time frame, we had every reasonable basis to believe that there may be an investigation happen in the future. This was a fresh new incident. It was just unfolding. And also, again, not to call into disputes of the factual record, but I would say, as I've argued in the brief, that on the face of that notice, there was going to be additional investigation. Videotape was sent over to a major to review, and the inmates were being referred for disciplinary proceedings. So again, I do take some issue with the notion that the record would support that. But putting that aside, we are not required to show we took an investigation, and I think that's clear.
Well, I'm just talking about your analogizing it to Bauman, and it seems like that was
Sure.
the court found to be really crucially important in terms of the balance on the employer side, the weightiness of the interest on the employer side. And here we don't have any examples of going after people for this kind of disclosure. I also, and I can ask Mr. Hannum, but Johnson herself didn't publicly disclose the information.
I disagree, Your Honor. She disclosed it to Hannon and had
She
no right
disclosed it to
to have,
Hannon.
he had no right, or the law group had no right to have that information either.
Well, if she is in her role as a union leader, conferring with counsel to figure out what the recourse is for the people she represents.
He does not have a right to confidential DOC information, Your Honor. There's no exception for the union's attorney to have access to this information. And again,
Do you have where's the clearest place that I can find a
I could-
policy about that?
there's several policies that deal with it. None says the union attorney doesn't get the information. There's just no exception there. So we've got the confidentiality agreement that she signed in November 2015, which again lists several categories, including incident reports as things that are to remain confidential. We have the FOIA policy. We have the
There's also under
email.
under the Whistleblower Act, there's a safe harbor.
Oh, sure, absolutely, Your
for
Honor.
just a situation like this.
And we're not disputing that, but she didn't follow the procedures under that safe harbor provision. Again, remember, that safe harbor provision deals with disclosures to your own personal attorney for purposes of determining how to disclose the information. The Hannon Group was not Ms. Johnson's personal attorney.
No, they were her attorney in the
But they weren't-
role that she was playing, which was independent of.
They did not represent her. They represented the union. And again, and
She
then,
was also representing the union.
but in addition to that, Your Honor, there are limited bodies that you can disclose that information to.
Wait, was she a union representative? You're not answering my colleague's.
I'm sorry, yes, she was absolutely. She was a union leader. She was the executive secretary of the union. But I'm saying that the union did not represent her in her individual personal capacity.
No, but she was acting as a union leader in speaking out on behalf
Yes, but as a,
employees of the Department of Corrections. And
and I don't dispute that, Your Honor, but that did not give her license to disclose
Are you
confidential.
counting her as a management person?
I'm sorry.
Are you counting her as a management person?
She was a sergeant. She was in a leadership position. Oh, you mean within the union? Yes, I
No,
would.
In terms of confidentiality rules, are you counting her as a management person who was bound by confidentiality rules?
I'm counting her as a DOC employee who was bound by confidentiality rules. All DOC employees are subject to these provisions. But yes, she was in a leadership role. She was a sergeant, lead correctional officer, and had been so for some time, which again makes, I think, her conduct so much more egregious because she should have been aware of the DOC's policies on confidentiality and had a role of advising junior staff members about that. So
let me ask you, Ms. Anderson, if the evidence shows that there was a viewpoint-based retaliatory effort to punish Ms. Johnson because she was embarrassing the Bureau, the department, where does that figure into the analysis? Does it have any role in balancing, like when you're looking at employer interest, and if the employer says, we have a really strong interest in HIPAA privacy, we have a really strong interest in non-disclosure of the identities of department employees, in this, for example, in the use of force, email, problematic. But if the reason that the employer is actually asserting its prerogatives in that situation is because it really is embarrassed and it's really angry at an employee. And I'm not saying that's these facts, but I'm just trying to understand where it does that downgrade the substantiality, the heft of the employer's interest at balancing, or does it only come in when we're talking about,
I think it
motivating
comes
factor
Right, I think it comes in at the third step,
Only.
Your Honor. I think when you're looking at the second step, that the Supreme Court's been clear that the two things you're looking at are Ms. Johnson's interest in speaking to the public and the public's interest in hearing what she has to say, and then the government's interest in keeping the information confidential or taking corrective actions for the disclosure of that information. It's at step 3 where you get to the what was the motivating factor in this case. And if you get past step 3, there is some animus. There's been a determination that it was motivated at least in part by some improper animus. And that was what brings you to step 4. And at step 4, what we look at is, would the employer have taken the same action anyway? And the district court, I think, found in this case that there was evidence. The district carried its burden to show by a preponderance of the evidence that we would have taken the same action anyway. Where the district court misstepped was at the pretext stage, where it didn't apply that but-for standard of causation, merely found that animus could be a partial motivating factor in the case. And when you look at how do you show the but-for prong? How does Ms. Johnson demonstrate that our real motivation was an improper reason? There's usually 2 ways you do that. You do that by showing that the reason given for the termination was illegitimate or false. And I don't think there's any dispute here about that. And the district court found that we had a legitimate basis for disciplining her. And then the second way you do it is by showing usually similarly situated comparators were treated differently. And Ms. Johnson's not offered up a similarly situated comparator that was treated differently, nor has she pointed to any other evidence in the record that would suggest that the district's explanation here was pretextual. And I see that I've really eaten into my rebuttal time.
I mean, as long as we're interested in asking questions, we don't hold it against you if you go over the time. So just circling back to make sure that I have your answer clear. If there is an asserted employee interest in speaking publicly on matters of public concern, and we look at, what at the context and what the person says and how it relates to what's going on in the world, and we say, okay, public concern. And the employer has policies on the books that it never actually enforces. People violate them day in, day out. Again, not this case. I'm just trying to get clear on the legal principle. And they say, these are really important policies of ours. The person violates and they say, this is a violation. The employee says, yeah, I did actually technically violate that policy, but you're after me because you disagree with what I said. And so when you say that's your interest, it's actually not your interest. There's no role for that in that balancing inquiry.
I don't think so, Sharon. It's our interest in the information, I think, that's at issue there, and the impact of its disclosure on our governmental operations. Right. So disclosing the names of employees. And
so the interest isn't really tied to the policy or not. It's just looking at sort of facts in the real world.
No, I think it's tied. I mean, the policy exists because of the district's interest in those goals. So you're sort of pushing back though on my kind of formal, like, is it your interest or not? And you're saying, well, right. You look at more functional. Again, I think so. And I think, again, to the extent that there's some improper motivation, that's taken into account at the third step of the Pickering test. I mean, we know no need for the third step if it was baked into the second already. And so I do disagree that that's the proper formulation of the analysis.
What is it in your confidentiality rules, if I can understand better, that says a person who is a union official but has management responsibilities is prohibited from sharing information that person properly has in hand with other union persons?
Again, Your Honor, the confidentiality provisions are also in the collective bargaining agreement, which binds all union members, including union management, not to disclose information that the Department of Corrections designates as confidential or deems to be confidential. So that's a wholesale.
Not to disclose, you're missing my question. Not to disclose, obviously there's disclosure because she got the information to be able to disclose it. And she was involved with a committee of union people, right?
Correct.
And everyone knew that was part of her official responsibilities in the operation.
Correct.
What is it in the confidentiality rules that says, in that kind of a situation, you, a union official who properly have this information in hand, cannot share it with other union officials?
It's not that she shared it with other union officials. It's that she shared it with a union attorney who is not an employee of the Department of Corrections.
That's all. It's a simple question. I'm trying to figure out where it is you think she stepped away from the confidentiality.
She
had a right to be able to share it otherwise.
she could share it with all the members of the union management team, who were all Department of Corrections employees and who would have independently had access to the information. It's that it went to the union. But it didn't only just go to the union. If you look at Ms. Johnson's declaration, she knew when she gave it to the union that it was going farther than that it was going to be used in litigation and disclosed publicly. And it was, in fact, her emails were attached,
No, I understand. I
unredacted.
just am trying to understand
Right.
the reach of the confidentiality.
Certainly. It would, anything outside the Department of Corrections or a Department of Corrections employee, Your Honor.
And the case would have been a different case if she had, it wouldn't have been a different case in your view if she gave it to counsel and just said, of course, if this is going any further, you have to redact the names.
No, I think the counsel wasn't entitled to it. I draw the line at anybody who's not a DOC employee without prior
So if it went to
authorization.
counsel and counsel never disclosed it to anyone, same result?
I believe so, yes. It's outside of DOC and outside of DOC's control at that point. And we see what happens here. We have no control over the union attorney. He disclosed it to a reporter, sent it to Meeking and litigation, attached it to the union's own litigation. So yes, and that's the very reason why we want to retain control of that information.
So if Booth and Patton were looking at our circuit precedent at the time that they acted in this case to decide whether they could fire Johnson just based on her emails, what would be the best case?
I mean, I think Bauman and Braderman are the two cases. I think Braderman is more helpful to our position, but those are the two cases in this circuit. But again, when we're looking at clearly established law, we're looking for law that says it's unconstitutional in these circumstances to take this course of action. And it's Ms. Johnson's burden. It's not the district's burden, or I'm sorry, I'm representing individuals here. It's not my client's burden to identify cases that support what they did.
Right, I understand. I just wanted to know your position
Certainly, yeah,
on
but yes,
the
Braderman
law
and
that you're
Bauer
relying on.
would be the two circuits. And then I've cited a few other decisions from other circuits. Again, as I say, I'm unaware of any case where a court has found firing an officer for disclosing confidential information in the course of speaking as a citizen on an issue of public concern is unconstitutional. And with that, Your Honor, if there are no further questions, I would hopefully have a couple minutes for rebuttal. Thank you.
Mr. Hannon?
Good morning, Your Honor, and may it please the court. This is clearly a factually intensive and densely factually intensive case, but the outcome is very logical and understandable. Let me talk first about a point that Your Honor made, Judge Fullard. That is, things sort of started over again when we got to the first hearing examiner's decision on June 30th. The process administratively is that the proposal for removal goes to a hearing officer who receives written and personal presentation from Ms. Johnson. At the conclusion of that, this attorney wrote an opinion saying that two important things, that Ms. Johnson's disclosures were permissible under the District of Columbia Whistleblower Act. And secondly, that her firing was retaliatory. Now, imagine these facts going to a jury, which on the status of the case now, they will. Where does that come from? That comes from the confidentiality agreement that the government relies upon that Ms. Johnson signed at the beginning of her 30-year career. And at the end of that confidentiality agreement, it says quite expressly, these restrictions do not apply to the District of Columbia whistleblower statute. You are free to do so. The other
Why
thing,
did the hearing board say that Johnson could be punished?
I missed the question, Your Honor.
Why did the hearing board say that Johnson could be punished?
That is the hearing examiner. So in the first instance, she suggested that there might be some minor punishment.
That seems an odd suggestion if Johnson did nothing wrong. And if, as you just said, the hearing examiner concluded that Johnson did nothing wrong.
Well, Your Honor, let me pose the following to try to explain the reasoning of the hearing examiner. After that process, Mr. Booth had his people write a remand order, which Judge Contreras found to be highly irregular. And he has cited cases saying that if the
I saw.
government, okay.
But I think the question was prompted by Ms. Anderson's point that if there's a carve out, if there's a safe harbor under the Whistleblower Act, then it may have been an irrelevant error because the hearing officer isn't imposing an alternative, sanction, but the hearing officer said what seems to be erroneous, that if there's a safe harbor, then no discipline would be imposed. And so I guess the question is, how do you address does that suggest that the hearing officer was otherwise off track or somehow misunderstanding the nature of the safe harbor?
What the hearing officer did and what Mr. Booth did with respect to the hearing officer is grist for the mill of what the jury is going to hear. If the government can explain why the hearing officer did that, they can try to do that before the jury. But the important issue that I was trying to reach.
I'm getting from your answer that you cannot explain why the hearing officer would suggest discipline while finding that Ms. Johnson did nothing wrong. And if you can't explain why the hearing officer would do that, it strikes me that the hearing officer's determination is pretty inexplicable.
Well, I don't think it's inexplicable given the fact that the Whistleblower Protection Act allows everything that was done here. The issue of penalty, I can't explain why she did that, except perhaps she wishes, I'm sorry.
No, you can finish your sentence, please.
Well, she wishes as a government employee for the District of Columbia to try to give something back to the government. And let's look to what she did the second time, which is really, I think, important to answer your point. Booth did his remand. He gave her soup to nuts about HIPAA and everything else. And her next decision was, well, and this goes to Judge Edwards' point. She gave it to her lawyer, Mr. Hannon. Mr. Hannon represents the union. He didn't represent her. So here giving it to me was a violation. And then my passing it on to the press, she's responsible for that because I represent her. That's the gist of the second decision by the hearing officer.
Let me change tack a little bit.
Yes, sir.
Do you know of any case in this circuit or Supreme Court where the court found a First Amendment violation after a law enforcement officer disclosed confidential information?
On that description, I can't think of one.
And same answer if we expand beyond this circuit?
I can't think of one. You have one in mind, apparently.
No, I was wondering if you did. Let me ask a separate question. How do you show causation, or how should a court think about causation at step 4 of the Pickering analysis? So,
well, Ms. Anderson asks you to impose a but-for standard, and it doesn't appear anywhere in case law. It doesn't appear anywhere in jury instructions that are found in the various different circuits. But in any event, I would commend to the court a 2020 decision of Justice Gorsuch in Bostock versus Clayton City, Georgia. It was in a little bit of a different context.
A little bit?
It was a discrimination case, but it talked about but-for and what does but-for mean. And the argument that Ms. Anderson is making here is that if the standard is but-for means solely. So Ms. Anderson would want the judge to have to decide the fourth factor and inevitably the jury by requiring Ms. Johnson to counter the government's argument that they would have fired her in any event, which they have to meet by preponderance of the evidence. But at that point, Ms. Johnson must prove, oh no, it was only solely because of my speech. And that standard doesn't appear anywhere in the law. It increases the standard that is imposed under the third factor. And it also is not what we think it is.
I take her standard to be a little bit different, not too far from what you said, but a little bit different. I take her standard to and by that I mean Ms. Anderson's proposed standard, to be there's no causation unless the government would have fired the employee absent absent the unprotected conduct.
Protect.
Right.
Sorry, would have fired the employee absent the protected conduct.
And at that stage, Ms. Johnson has to show it was pretextual. And that then to show whether it's pretextual or not requires that either the purportedly legitimate reason be a not legitimate reason, or that there's a similarly situated comparator who was treated differently. Well, there were no others that were treated the same way that she was. Were there any similarly situated comparators who were treated differently than her? There's no way to know. So have you identified any similarly situated comparators treated differently than her? There's no way. They acknowledge they haven't disciplined anyone. And that goes to our side of the fulcrum here. But my inartful articulation of the test, but as Judge Pillard artfully corrected, that is the correct test, correct? Which is the way that Judge Pillard helped me articulate the test for causation. That is the correct standard. That they have a preponderance standard to prove they would have done it anyway. And if they meet that standard, this is jury question. The jury is told if they meet that standard, then she needs to rebut it by the same standard of evidence. It's not but for. Did the Department of Corrections retain any people who gave press conferences or interviews around this time criticizing the Department of Corrections handling of COVID? Retain? Yes. They didn't discipline any others. Good.
Let me ask you so there are two different buckets of speech that are in play. One is emails, including the use of force email, and the other is the media interview. And I take the government, and they can correct me on rebuttal if they want, but I take the government to agree that the interviews were protected expression in Ms. Johnson's personal capacity, and their dispute with you is over whether the interviews played a sufficient role or any role in Johnson's firing. But for you, based on the evidence in the record and inferences favorable to your client, could a reasonable fact finder conclude that the media interviews alone caused her firing? The media interviews,
April 27th?
Yeah, alone caused the firing.
No, not on this record, because
your case depends on a ruling that Johnson had a First Amendment right to forward the emails.
No, I think that's a little bit of a different issue. And in this case,
that's my question to you. How are the two related? Are they related? So she forwarded work emails in violation of bureau policy. That was a stated cause for the firing. Do you have to, in order to prevail, do you have to show that she had a First Amendment right to forward those emails? Or can you say, well, whatever happens with the emails, independently, we have a First Amendment claim based on the interviews and their reaction to the interview?
My position, Your Honor, is that the forwarding of the email to her attorney is not a violation of anything, because under her confidentiality agreement, she's specifically authorized to blow the whistle. So there's no violation of any policy to begin with. And as Judge Contreras noted, if they felt serious about this issue of confidentiality, they would be marked. If they felt serious about HIPAA, the HIPAA warnings would have been included in all of these issues as well. If you're going to talk about the evidence in the light most favorable to Ms. Johnson, what I would say about Judge Contreras, he's a very balanced judge. He does not call somebody's argument unreasonable or specious or imaginary. But he does rule. And
Go ahead, you can finish your sentence.
so if you look at the evidence in the light most favorable to Ms. Johnson, what I see is what the Supreme Court has talked about as an imagined government interest to try to squash her First Amendment rights, or a specious government interest. Barron's versus Pelletier talks about that. When we're talking about qualified immunity, we have two things to balance here. On the one hand, we don't want to subject a government official to a trial where they might have immunity. And on the other hand, and the cases make this clear, we don't want the government to be posing specious and imagined government interests when somebody is exercising a First Amendment right, as is clearly, the case at this point. And so if we were going to treat everything in the light most favorable to Ms. Johnson, what we would say is they targeted her, they swiftly went after her, they combed all of the rules and regulations to see if they could find some that she violated. They then created a notice of removal, finding her to have violated fictitious confidentiality rules. Now, Judge Comparis doesn't call it that.
Go ahead.
You're conflating the confidentiality. Do you assume that there can be no valid confidentiality rules pursuant to which an employee, a management person knows I can't talk about?
Oh, no, I agree with that entirely. There are
Okay, so wait, but you're
confidentiality rules.
lumping them all together.
Well, if you release the information pursuant to the DC Whistleblower Act, you're specifically authorized to do
Isn't
that.
there a process you follow if you're going to be pursuing the Whistleblower Act? Was that process followed here?
No, sir. Imposing an internal administrative process before someone becomes a whistleblower is not part of the fulcrum. And HIPAA, by the way,
It's not part
you
of-
asked, not part of the fulcrum, not part of the process within the administration. A whistleblower doesn't go to the supervisor and say, I'm going to send this information to our lawyers because people are dying in the jail. So there are rules of confidentiality.
Right.
If you want to know on the facts of this case, whether there are any rules of confidentiality that relate to the use of force email, for example, the answer is no, because it wasn't marked confidential. Were any of the
Did the
documents?
policy require that it be marked?
Yes, it does.
It required that it be
Yes, it
specifically marked
does.
to be covered.
Absolutely.
Do you have a JA site for that?
Absolutely. And
Is there a JA site for that?
do I have a citation
Is
for
there-
that?
In
Is there a
the appendix where we can see the policy requiring that?
Yes, it's under the rules of the Department of Corrections. And I can't cite the point in the appendix, but they talk specifically about having to mark items confidential that are confidential outside of HIPAA. And then they have very specific regulations requiring marking HIPAA. Now, they found her to have violated HIPAA, yet they don't recognize, and it's a administrative regulation. An administrative regulation permits Ms. Johnson to provide the information to me, very specifically,
To provide
to provide the information to an attorney. HIPAA
personal attorney?
to an attorney that represents, can't remember the language, but it represents her or a colleague or somebody of interest with her.
But that doesn't mean there's no confidentiality rule in place, even though she can talk with an attorney. There can still be a confidentiality rule which says with respect to this kind of an information, and you may think you're going to be in trouble, so you want to talk to your attorney, you can, but you can't go out and share it. That's against the rules of this operation, this government operation. That's their claim. You seem to be saying there's no such thing as a confidentiality rule here.
No, Judge,
I'm not understanding.
I'm not. If it's legitimate, let's assume it's legitimately marked as a HIPAA confidential document.
You can have a confidentiality rule. It's not HIPAA. You can, I'm not going to go into that. The question in this case is, was there a confidentiality rule that was breached? Did the district court say there was none?
it cited that as an interest of the District of Columbia to be balanced against her First Amendment right. And it discussed basically the two prongs of their interest. One, with respect to the use of force email, they said that the use of force email is confidential because it's a pre-investigatory document.
All right.
And he said he dispensed with that because there was no investigation conducted at all.
All right.
And then the other part is the medical side of things, the HIPAA side of things. And I'm not making myself clear, but let me try again. Let's take the generic Department of Corrections confidentiality requirement on medical information. And let's assume it's marked. So if it's marked and it has to do with medical information for an inmate, then it would be a violation to disclose it unless you're doing so under the DC whistleblower statute, which in her confidentiality agreement expressly permits her to do that. And the HIPAA regulation, which is in the CFR and it's cited in our papers, that regulation similarly makes it clear that someone in a workplace can provide information about the potential death of inmates and correctional guards to an attorney, which is what was done in this case. Now, the District of Columbia tries to have it both ways. At one point, they try to say, I'm not her lawyer and HIPAA doesn't apply. And then in the next instance, they say, well, I am her lawyer. So the disclosure to the press is my problem.
Those aren't necessarily in conflict because they're saying you're not her lawyer for purposes of you being effectively her for purposes of obtaining this confidential information, but you are a conduit of hers. It doesn't matter whether you're her lawyer or not, that you're someone that and I mean, I assume you've talked to your client about this, but it seems like you have a conflict in this appeal, potentially, because there are aspects that you're actually involved in that could have shielded her in arguments that haven't been raised.
Well, I appreciate that. And the point I think that needs to be made with respect to that is that there's no question that Ms. Johnson had no idea that I was going to send this to the press. No question about it. That's a fact.
Is that in the record? Is there a declaration from the record?
It is in the record.
It is in the record?
I don't have it at my fingertips, but there's no dispute about the fact that I believe it's in the hearing officer's report. There's no dispute about it that she didn't know. And the hearing officer in the second decision held her responsible for that because she was under the rules of professional responsibility going to assume that since her lawyer did it, she did it.
I don't understand how we can consider that fact as a fact on the record if you can't identify where it is in the record. It's not like we can take advantage of the unusual situation where a fact witness is also her appellate lawyer and then find some facts here at the appellate argument.
It's certainly in everything that we wrote and presented to the hearing officer. And my recollection is she wrote that in her decision, which is at 366, I think, in the appendix. And Ms. Anderson can dispute me, but I don't believe that her side, I think in her brief, she actually indicated that. So
Ms. Johnson sent you the use of force email and the emails with the HIPAA information, correct?
Repeat that.
Ms. Johnson sent you the use of force email?
Correct.
And the emails with the HIPAA information, correct?
Yes.
Okay.
Or myself or my partner.
Okay. If the First Amendment does not prohibit the government from firing Ms. Johnson for doing that, do you lose your First Amendment claims in this case?
That's an interesting question. And of course, it assumes the outcome. And in addressing that, what I'd like to point out is that the government, in its opposition to our motion to dismiss and in their cross motion for summary affirmance, they say that they agree with you.
I read their motions,
Okay.
but I'm asking, I know you don't agree with the premise that the First Amendment does not prohibit the government from firing Ms. Johnson. But I know you don't agree with that premise, but if you can assume that premise, do you lose your First Amendment claims in this case?
I I got it. So here's the issue for the court, in my view. Even though the opening brief for the government relied on factual disputes, right? And they've now changed their position. They're telling you, oh no, it can't be a factual dispute. So here's what the position I believe is for this court and why this court should not exercise jurisdiction. The argument being made here is that when the trial judge does the balancing and comes out in favor of there being a First Amendment violation, looking at both sides of the case, because there's a qualified immunity claim in there, those who didn't receive qualified immunity, for whom it was denied because of the factual determination under the First Amendment prong, if it goes to the Court of Appeals and you disagree, not only is the qualified immunity decision wrong, but the First Amendment claim has to be dismissed as well. So that's where you're headed, I believe. And in my view, that violates the final order rule, allowing qualified immunity, which can come to the court on very limited circumstances where there's no dispute as to the fact, to then carry the day with respect to a decision against the government. They lost on summary judgment on their First Amendment.
I think I have your answer. And I think it's that even if sharing the emails with you was unprotected conduct unprotected by the First Amendment, you can still win on your First Amendment claims because
if it's unprotected conduct.
If the email forwarding was unprotected conduct,
Under the First Amendment.
I think this is related to a question I asked earlier.
Yes.
Maybe you can correct me if I'm wrong, but that I don't think you answered, which is if the provision of the emails is not protected. In other words, we've heard your safe harbor arguments. We're just trying to understand how the different pieces of the case really fit together. If we were to hold that either the defendants are qualifiedly immune on the emails, or that the record doesn't support Johnson's claim on the emails, is there a separate claim, First Amendment claim, based on the interviews? And if so, how do you respond to Ms. Anderson's argument that there's no record evidence that the decision makers were ever even aware of those interviews when they made the decision and reaffirmed the decision to fire Ms. Johnson?
You need to focus on the April 27th interview. And the only evidence on the government side was Miss Patton's declaration, which was prepared by counsel, and Judge Contreras examined that very, very carefully. And he concluded that her declaration wasn't sufficient to demonstrate that she or anyone had made the decision to remove Ms. Johnson before April 27th. And he cited to the subsequent conduct, the presentation of the information to the human resources folks, the creation of the report by the lawyers, it coming back to Ms. Patton and her signing a notice. Now part of that, I hesitate to point out, is that when Ms. Patton signed that notice, it was just a notice. She did not express any opinion whatsoever about whether she should be removed or not, or had done so at any other time. So what I think you would have to do, Your Honor, is you would have to reject the evidentiary finding that Judge Contreras made with respect to that. On its face, he says it doesn't say that. And in the light of subsequent conduct, it doesn't say that. And he doesn't say this is pretextual, or it doesn't say this is something a lawyer did. What he says is that the jury can either conclude that they had made a decision before, or they could conclude in her favor they hadn't made a decision before. I also want to comment here on that case law. Ms. Anderson says that the case law says if a removal is, quote, contemplated before the actual protected conduct.
I think the more challenging record question for you is, she's asserted that there is no evidence in the record that the decision makers were aware at any time, even before the remand to the hearing officer, of the May 1st publication of the interview results of the interview that she gave on April 27th.
Well, that's
And what is your response on that?
so the only evidence, as Ms. Anderson has indicated, is the declaration of Ms. Patton.
So
And
I mean,
Judge,
don't you have to have
evidence on your
affirmative
side?
evidence
Sorry?
on which a jury could depend? If I'm the fact finder and I'm trying to decide, okay, maybe I disbelieve that declaration, but what am I depending on other than speculation that these decision makers learned of
No, it
these
wasn't.
statements?
It wasn't speculation
I want you to tell me why not.
because the trial judge, Judge Contreras, looked at the facts of the case. He said, first, her declaration doesn't say what counsel says it says. And the second focus they took was the subsequent activities of what transpired before the notice was actually sent, and indicating that there's no way to know when it was contemplated that she's going to be fired. But I don't think that the case law that the government describes with respect to this contemplation, that if you contemplate something before you know of the protected, I don't think that.
Just put that aside.
Yes, sir.
Mr. Han, I'm at JA 519, and it's paragraph 33. This is Ms. Patton. I have never seen footage of any interview Sergeant Johnson participated in and have no knowledge of whether it took place, what statement Sergeant Johnson made, or when, if ever, it was published. What in the record contradicts that?
Isn't it the April 28th? There's maybe it was you, an attorney for the union notifying the department that Johnson was going to give this interview?
Yes.
You
Is
haven't
that it?
mentioned that.
Sorry.
You have not mentioned that in response to our questions.
Yes, it was.
So they were
She gave it in-
she's going to be talking to the press about this crisis in the prisons, in the jail.
Yes.
That would be one way that they know that she's given an interview.
Well, I don't think the issue is what you posed, respectfully, because I think the issue is whether she contemplated before April 27th.
I know that's the issue
Okay.
to you, and I will give that thought and reflect on whether that should be the issue. A different issue that I'm trying to figure out the answer to right now is, in light of this statement that I read, that Sergeant Johnson had no knowledge of whether whether any interview took place, no knowledge of what statements were made. Is there anything in the record that contradicts that? I understand that the April 20th email put Ms. Patton on notice that there would be an interview, but that email did not say what statements Sergeant Johnson made, or even if the interview ended up taking place, as it happened to have taken place the day before, but it aired a few days later. Okay. So assume, for the sake of my question, that I think that April 28th email does not contradict this paragraph 33 statement. Is there anything else in the record that you think contradicts this paragraph 33 statement by Ms. Patton?
Judge Walker, Judge Contreras, based on those portions of her declaration, found that certain of the disclosures that were part of count one, the DC whistleblower complaint, complaint could not be proven. So he did take that into consideration. My point is that it's not relevant to the First Amendment balancing, because that had to do with the argument that the government's making that because there was a contemplation of removal before the interview, that they're protected. So yes, Judge Contreras took note of that by striking some of the disclosures that underlie the DC whistleblower statute claim.
And how does any of that contradict Sergeant Johnson's statement that she has no knowledge of what statements Sergeant Johnson made in the interview?
And I don't know what interview that's referring
The
to.
April 27th interview that aired on USA 9 on, I think, May 1st.
I don't think that modifies my answer, because if that was relevant to the anticipated removal or contemplated removal argument, then Judge Gutierrez would have commented upon that.
I mean, I will say, I think you're giving the best answers that the record probably allow you to give, so I don't fault you for the answers. If I don't know who will write, I don't know how we will decide this case. I don't know who will write it, but if I were to writing this case, here's what I would say. I would say counsel for Ms. Johnson was unable to identify anything in the record showing that Sergeant Johnson had ever seen that Patton had ever seen what statements Sergeant Johnson made in the WUSA 9 interview conducted on April 27th. Would that be a fair statement, in my opinion?
Forgive me, because it's not relevant to the First Amendment.
Okay, I think we have your answer.
Because that doesn't make a difference. If she contemplated removing her before the 28th, and all this other events took place, that's not going to, carry the day as far as the law is concerned, because Judge Contreras made factual determinations that her declaration about when she contemplated removing doesn't prove that legal
removes
principle.
her defense. It doesn't make your case. I mean, Judge Contreras does say that the emails are not everything. Johnson expressed her dissatisfaction with the Department of Corrections response to COVID in other ways that have nothing to do with the emails, including her late April interview with a local news station. So he does rely on that. And I suppose we have to go back and comb through and see where he connects the dots that they were aware of that.
Forgive me, but it doesn't make a difference on the First Amendment analysis with respect to the legal argument of a previous decision to fire her before.
Previous decision to fire, we're putting that aside. Imagine we are convinced by your argument that there was no previous decision, that the decision, or that even if there were, they remade the decision later, right? When they said to the hearing officer, no, you can't reverse the termination. You should support the termination. That all happened afterwards. So put aside their effort to say, oh, everything we decided was before April 27th. Just put that aside and assume that's not in the case. Then the question is, well, still, do we have evidence on which a fact finder could say, but by the time they later made the decision and carried it through to fruition, they did know about more than the emails. They knew the interview she gave in late April to the local news station. And in fact, it's fair to say that was a motivating factor in the decision, and they wouldn't have made it but for.
And I'm supposed to ignore the June 30th decision of the hearing officer that was.
Did anybody tell the hearing officer about that interview?
The hearing officer had the proposal for removal, and they had our response to
The
it.
proposal for removal, I don't think depended on that.
What I'm talking
It did
about,
not explicitly depend on that.
what I'm talking
I'll
about
look at it
is,
again, but-
what I'm talking about is what Your Honor referred to as sort of the clock starting over again after the hearing officer's first decision finding in favor of Ms. Johnson, and that pursuing the removal after the hearing officer's first decision was intentional misconduct by the government in violation of her First Amendment rights. That's
I'm good. Thank you for your.
Anything else, Karen? All right. Thank you.
Thank you.
Just, I think hopefully 2 brief points, Your Honor. Going to the question of the April 1st and April 27th interviews, I just want to be clear as to Booth, who was the final decision maker in the case. The district court found no evidence that he knew of either of the 2 interviews. As to the April 1st interview, the court also found that Patton knew nothing about it. The only interview that's at issue here is the April 27th interview, whether Patton knew about it and what role she played in the decision-making process. The other point I wanted to make, just going back to
But
the,
the district court, I think you correctly stated the standard under Johnson versus Jones, that if the district court is saying, look, the record supports, read in the light most favorable to the plaintiff, the evidence of record supports that Patton was aware of the WSA 9 interview, and a reasonable jury could find that that was a motivating factor, that's not something that's before us.
I disagree.
Under Johnson versus Jones.
Under Scott versus Harris, I believe it is. And other circuits have recognized that very narrow exception. It has to be blatantly contradicted by the record. And there could be no evidence.
Blatantly contradicted.
So it blatantly contradicted in two ways. There's only two pieces of evidence in this record. Patton's statement, she didn't know about it. And that April 28th email that didn't reference the April 27th interview and only suggested that Johnson was going to give an interview at some point in the future. That cannot establish that Patton had actual knowledge of the April 27th interview. It
It
just
seems like pretty fair circumstantial evidence that they're in this grappling with her. She's blowing the whistle. She's sending out email information saying, look, it's a crisis in there. They're not doing COVID. She's the poster child for objecting to the policies on COVID protection of employees and inmates in the jail at this time. They're not going to learn something that's been publicly broadcast.
again, what's the evidence in the record, Your Honor? It's speculative.
No, the evidence in the record is that it's completely publicly available and that they knew it was happening. So it's circumstantial evidence.
I don't know that they.
But you're saying that the record blatantly contradicts?
Yes, and in our view, it does.
Okay.
Yes, I stand firm by that, Your Honor. And then I just want to go back to the hearing examiner's initial determination regarding the 22 emails that she found to be protected by the Whistleblower Protection Act. As the court knows, there's a whistleblower claim in this case. Of those 22 emails, in this case, in her whistleblower claim, Johnson only argues that one of those 22 emails were protected by the Whistleblower Protection Act. I think that's very telling in terms of the accuracy of the hearing examiner's initial decision. Once we explained to the hearing examiner what the Whistleblower Protection Act actually protected, she agreed that Johnson's removal was appropriate in this case. I'm sorry, third point, and I hate to do this, but I just want to, last point, counsel's concession today at the podium regarding the availability of clearly established law is very reminiscent of the concession at the podium in Vasquez, which in this court's words killed the claim that there was no qualified immunity. And on that, I will ask that the court reverse. Thank you.
Case is submitted.
Case number 24-5294. Public Employees for Environmental Responsibility and Center for Environmental Health Appellants versus Liam Zeldin as Administrator of the United States Environmental Protection Agency and Environmental Protection Agency. Mr. Sussman for the appellants, Mr. Anderson for the appellees, Ms. Ellsworth for the intervener appellate.
Morning, Mr. Sussman.
Good morning, Your Honor, and good morning to the panel. May it please the court, I'm Robert Sussman. I'm representing the plaintiff appellants in this case, Center for Environmental Health and Public Employees for Environmental Responsibility. So This case is about Section 4F of the Toxic Substances Control Act. And Section 4F is an action forcing provision that compels EPA to address unusually urgent and threatening chemical risks that call for expeditious protection of public health. For purposes of this appeal, there is not a dispute that the high bar for triggering Section 4F has been met. The district court found, based on the allegations in our complaint, that EPA had a non-discretionary duty to initiate applicable action under Section 4F in 180 days. And the judge also found, based on the complaint, that the 180-day clock began to run by March 29, 2023, and thus in October 2023, EPA was in violation of its mandatory duty. And EPA says in its brief that, again, for purposes of the appeal, it is accepting those conclusions and proceeding on the basis that the application of Section 4F was a given. So the argument that the government is making here is that even if EPA was in violation of its duties under Section 4F, it discharged those duties after this case was filed by publishing what I think we can agree is a bare bones request for information on fluorinated containers on September 24, 2024. And I think it's pretty clear that this information request did not discharge EPA's non-discretionary duty, and instead, we would say that the plain language of the statute shows that EPA was obligated to issue a proposed rule under Section 6 of TSCA by the 180-day deadline for action. Sorry, Your Honor.
I want to make sure we have the facts right here, okay? This is a strange case to me in any event, in that, as far as I can see, the agency did exactly what it was supposed to do in this case.
The agency
did exactly what it was supposed to do in this case.
Okay.
It got a petition from those on your side requesting action of the sort being taken here. They granted the petition. They credited it and said there was serious information, a long letter. I was amazed when I looked at the record. So unusual. The government agency immediately says, yes, there's a problem here. We have to address it. And that's certainly not inconsistent with what 4F says. 4F talks about initiating applicable action. It doesn't say anything more than initiate applicable action under 5, 6, or 7. Those are potential rulemaking proceedings. And what the government did here was to initially say, we need to solicit information, which is normally done when you're invoking or may invoke rulemaking. That is a very normal procedure if you're invoking rulemaking. And that's what the statute says. If you read this, heaven forbid, statute that goes on and on and on, what it is really saying in 4, 5, and 6, if there's something here to worry about, you can invoke rulemaking. And if you decide not to, you should tell us why not. But in any event, when you invoke rulemaking, and it invokes the APA, it says follow APA procedures, which is what they are doing. They are asking for information preceding to making a determination. You can't start in one moment the initiation of rulemaking without knowing what it is you're going to issue a rule over. You have to get information to make a determination to narrow it down. And then you have all these risk determinations that the statute requires. There's so much more to be done. Your suggestion that they had to respond to your petition by within 90 days, having a rule in place, the statute doesn't say that. It absolutely does not say that.
Well,
As far as, I just want you to tell you what I'm seeing. As far as I can see,
No.
they have not done anything that's inconsistent with the statute at this point.
Yeah.
Nothing.
Well, I would respectfully disagree with that. The proceeding under which EPA was proceeding was the rulemaking provisions of Section 6. The rulemaking provisions of Section 6 are more prescriptive than APA.
It says initiate applicable action.
Okay, so
It
the
doesn't say
question,
initiate,
but,
doesn't say initiate a rulemaking.
well,
And
to-
agencies don't normally initiate a rulemaking without having determined what it is that they're going to pursue. And so
Well,
what they
they
did,
have
including
exactly
all of these,
determined what they're
all of
going
these
to pursue.
statutory provisions here, there are long sections on risk determinations, risk evaluation, which can go on. In fact, the statute says at one place, I think it says, take at least 60 or 90 days, no, maybe even more. In other words, it assumes it's going to take time to make the risk determinations of the sort that were to be required in the case of this matter.
Well, Your Honor, I think we need to look at what Section 6 says.
I did.
Section 6C1 says very specifically that the agency must propose a rule
When?
within 1 year
When?
after making a
Right,
determination
after making a determination.
of unreasonable risk.
After
The agent-
making a determination, what they've done now is they granted you a
They did
petition.
make a determination of unreasonable.
They made a determination that they had enough information to get started and to initiate applicable action.
Well, they had all the information that they needed to get started because getting started with a rule simply requires a determination of unreasonable risk. And all they need to determine in addition is how to eliminate the risk. And that is not a big decision. It cannot consider economic analysis. And it is certainly a decision that can be made within 180 days.
Is the deadline 180 days, but it's
No.
1 year? Do you make the determination of unreasonable risk? And that's happened. And then once there's a determination of unreasonable risk, then the agency has the three different choices to do.
Agency has to what?
It makes a determination of unreasonable
Right.
risk. And then
No.
And
That
then-
may be reasonable cause. It's not what you're saying. They make a determination. It may be reasonable basis to conclude. They haven't done the risk determination yet.
Well, they have.
That's a whole
They
other
have,
section
Your
of the
Honor.
statute. They're not even close to that yet.
I mean, they made that determination in December 2023 when they issued an order accompanied by a 200-page risk evaluation, which concluded explicitly that these fluorinated containers present an unreasonable risk of injury. And the obligation I'm referring to, while it ties back to Section 4F, is the obligation in Section 6C1, which says if the agency has made a determination of unreasonable risk, there must be a proposed rule within a year. Full stop.
I'm just trying to find in the addendum here, the Section 6 determination
Yeah.
language.
Are you looking in the statutory addendum?
Yes, but I think I'm looking in the government statutory addendum.
Yeah, I think that in the addendum, it's on page. Boy, page 5 of the addendum, Your Honor. Under C, promulgation
Right.
of section 6A
And it's
rules.
deadlines. If the administrator determines that a chemical substance presents an unreasonable risk of injury to health or the environment, in accordance with subsection B4A of section 6,
Right.
which is on
No,
4A.
That's a good question.
It's on
And
4A and it's
It's not in the addendum, but basically what it says is that EPA, to determine an unreasonable risk, EPA must do a risk evaluation which accomplishes 3 simple things. First, it's got to make the determination of unreasonable risk. Second, it can't make that determination on the basis of cost and other non-risk factors. Third, it needs to examine whether there is a risk to vulnerable populations, basically. And then finally, it must examine the risk under the conditions of use at issue. And so there are a lot of bells and whistles in section 6B about what EPA must do in the course of a risk evaluation. But the provision in section 6C1, which triggers the 1-year duty to propose a rule, simply refers to subsection B4A. And I think
B4A of section 6.
Yes,
which
section
is
6.
just what you were describing, which
Yes,
says
yes.
unreasonable risk, don't consider cost or other non-risk factors, and consider exposed or susceptible populations. And your view is that that had already happened in connection with the the invalidated section 5 action against
Absolutely.
enhance, that all of that information was known and being pursued up a dead end under section 5, and that now, I mean, I guess there's a question when the government has done something in compliance with its obligation either to act under section 5, section 6, or section 7. It acted under section 5. And how do we think about the deadline when the time has run? They were busy in good faith doing something that turned out not to fulfill their obligation, or let's just say for the moment that would be our decision, because they do argue that it did fulfill their obligation. But now they're moving over to a different way of fulfilling their obligation with
Right.
respect to a non-new use, right?
Right.
And the question is, how do we know, I guess, 2 things. One, how to treat the deadline. It's supposed to be 1 year from this finding of
Unreasonable risk.
unreasonable risk. How do we know when is that restarted? I mean, that seems like that's an issue of first impression. And then the other thing is the information that EPA already has. How do we know how that maps onto the requirements for rulemaking under section 6?
Yeah. Well, that's a good question. I mean, the determination of unreasonable risk and the risk assessment occurred under section 5 on, I think it was December 1, 2023. And the risk assessment, Your Honor, is in the joint appendix. It is a very copious, highly scientific, exhaustive, and comprehensive risk evaluation. And as I said before, it touches all the bases in subsection B4A. So I think the judgment that Congress made here is that if the agency has made a determination of unreasonable risk that touches those bases, then you don't need to go through the full Section 6B risk evaluation process and comply with all the bells and whistles in Section 6B. And the reason for that is EPA has already made a determination of unreasonable risk. So let's go right to rulemaking. And Congress said go right to rulemaking in 1 year. So I think that's where we are. And I to amplify that,
Where do you think it says go right to rulemaking in 1 year? It's not in 4F.
It's what?
It's not in 4F.
No, that's my point. It's in Section 6C.
And what about the deadlines and, excuse me, the language saying shall publish in the Federal Register a final rule not later than 2 years after the date on which the final risk evaluation regarding the chemical substance.
Where is that provision?
That's the next provision. So he's just looking at so the proposed rule is not later than 1 year
Yeah.
after the risk evaluation, and then a final rule not later than 2 years.
Right,
After the final risk evaluation.
And then
So-
goes on to say can extend the deadlines for not more than 2 years.
Well, they could do that, but I mean, they haven't done that, Your Honor. They haven't extended the deadlines. And I think another point, which is very important here, is EPA is not repudiating its determination of unreasonable risk. It is standing by that determination. It is sticking with the science, and it's not saying that we need to go back to square one
Right.
and do.
I mean, it's not directly saying that. Let me ask you to help us out based on where EPA now stands, do you understand EPA to be obligated to fulfill or meet these deadlines in Section 6? When and sort of where do you perceive EPA to be in the timeline
Okay.
that Section 6 sets
Well,
up?
I would say that it's a 1 year deadline from the determination of unreasonable risk, and that was made in December 2023. So a year later, in December 2024, EPA had an obligation to propose the rule.
Except wasn't it in some of that time litigating, it made the determination in the guise of the new use. And so I guess, don't they get some kind of restart for the time reasonably taken to draft a rule?
Maybe. I think that that's an issue for the district court in setting a deadline to comply with the statutory duty. And courts, when they do that, they don't hold the agency literally to the deadline in the statute, but they do inquire into the circumstances, and often they give the agency more time to comply than the statutory deadline allows. But that doesn't.
But I'm really asking you a question about how does the statutory deadline, it's not clear to me one way or the other whether they've missed the statutory deadline, whether they still have some time to meet it, because if they've done this whole frustratingly unsuccessful effort under the new use provisions, now they're kind of back at square one, but obviously they're not at square one for the expertise and information gathering reasons that you say. So there's something to be done there about getting into the traces for Section 6 operation.
I guess I would say the 1 year deadline in Section 6 is explicit, and it's mandatory, it's non-discretionary. But I mean,
1 year deadline to what? Propose a rule
to propose a rule.
after risk assessment?
Excuse me?
After risk assessment?
No deadline for risk assessment because that's
after
been
the-
done.
Right,
After
that's what he's
risk
saying.
assessment.
after the determination of unreasonable risk.
Yes. And so one way to look at it is Enhance was handed down by the Fifth Circuit in March of 24. So you could say, well, from that time, if EPA is back to square one, I mean, you're right that to say, let the district court figure this out, but, and obviously we're going to ask the government about this, but would it be reasonable in your view to say that that they should do it as soon as possible, but that under the terms of the statute, the most they should get is a year from March 2024 to turn around and promulgate a rule?
Yeah. I mean,
That or as soon as practicable.
I
as the statute
think
says.
that's a reasonable approach because up until the Fifth Circuit decision, the agency had a reasonable basis to feel that it was complying with Section 4F because it had issued an order and the order banned the fluorination of containers producing PFAS. And so the agency had every reason to believe that it could implement a ban based on Section 5 and not on Section 6. But that, of course, changed with the Fifth Circuit decision in March of 2024. So I think it's reasonable to say, okay, at that point, the game changed because Section 5 was out of the picture. Section 5 was no longer a basis for regulating fluorinated containers based on the Fifth Circuit decision. But the agency still had an outstanding duty, and I would say an outstanding duty under both Section 4F and Section 6C1. And so I would say at that point, the clock restarted.
All right, I have a question for you about standing. I don't think we have a case where an employee is determined to be effectively in the position of a member for purposes of associational or representational standing.
Yeah.
And I mean, if you had filed the case on behalf of these organizations and also these individuals in their individual capacity, that seems like that would be easier for purposes of standing, but.
Well, there are actually a couple of decisions which involve associational standing where the court looked to harm to the employee, the staff of the organization as a basis for standing. One of those decisions, I believe, was in the district court in this district. And let me see. It's Air Alliance Houston, the Chemical Safety Hazard Investigation Board. It's a 2019 case of the district court. And then there's another decision from the district court in Washington. It's called Institute of Cetacean Research v. Sea Shepherd Conservation Society, and the court said there that employees and volunteers may count as members for purposes of associational standing. And then in the Smith case in the Ninth Circuit, 2004 case, standing was based on an individual who was actually working on a program that the organization was carrying out. So I don't know that he was an employee, but he was a contractor. And it was the potential injury to him that provided a basis for standing. And Your Honor, the government is actually not disputing in this case that the CEH and Peter employees who have provided declarations qualify for demonstrating associational standing. They say that very explicitly.
But you know that unlike other issues, the fact that they may agree with you does not get this court off the hook in deciding whether they're standing. It's something, because it goes to our jurisdiction, it's something that the parties cannot stipulate to or waive. And so we still have to decide whether we're satisfied, notwithstanding whether EPA and Enhance are fighting it. Whether we think this is it feels to me like a potential broadening. I see the analogy where if these folks are, and they say they are, very aligned with the mission of the organization, the organization represents their views, they have input into the organization's positions, and however you look at it, associational or representational standing looks at those factors. So I see that in your favor, but it feels novel to me. And
it's novel, but there's some case law out there. This is
district court case law, which isn't binding on us.
This is not an issue of first impression, but I want to make one more point about standing, which is the Supreme Court in the Lujan case, and then this court in two additional cases made it very clear that when a case is at the pleading stage, which this case is at, the judicial responsibility is simply to look at whether the general allegations in the complaint seem to encompass the facts that would be necessary to establish standing. So this is a fairly low bar. It's not predominance of the evidence. It's just, do the allegations provide a kind of umbrella for the trial court to dig deeper and consider the evidence and the facts. So I guess what I'm getting to is that if you feel you have an obligation to determine its standing in this case, I don't think it needs to be a definitive determination. I think it can be based on the general allegations in the complaint, and the outcome would be for the district court to dig deeper and wrestle with the standing issue on a more evidentiary basis.
I'm not sure, because if you haven't already demonstrated your standing, I think we should dismiss the case. It was your burden.
Well, I think we've met the burden. I mean, we've.
But if you've met the burden, why would we remand to the district court to see if you can meet your burden?
Well, you've got to remember that the district court really addressed only one issue, which is the adequacy of the remedy. And then it found that the case was moot. And so standing was not raised or argued or briefed in the district court. So it is really an issue for the very first time in this court. And that's why we decided in an abundance of caution that we would submit detailed declarations. And we also thought there was an argument that under Rule 28A of the court's rules, this might be construed as a case reviewing administrative action. And so on that basis, we were required to address standing. And I think we did very fulsomely And if the court wants to dig deeply into this issue, which I don't think is needed, then I think the evidence is there to demonstrate standing.
Tell me, I'm sorry. Does the public petition section of the statute, which authorizes the request that the agency got in the first instance and they responded and got this thing started, does that say only an association can file that petition? I just can't find the words.
Well,
In other words, the assumption of these questions is you may lose on standing because you're not really showing an association as we require it. I'm not sure that section of the statute says it has to be an association or a representative group. It may say any person. And if you take
It does say
Allentown,
any person.
well, if you take Allentown Mac and what Justice Scalia said in Allentown Mac, you don't need an association in Allentown Mac. You need someone who wanted to river rights as against those who were wanting to use other uses. And he said that defined the Article 3 standing question as well as the zone of interest question. So that's the reason I'm not, but I'm not sure about that. My recollection is that statutory provision, which gets this thing started, which is what EPA responded to initially, said any person. So all we need here is a person who has the requisite interest here is within the zone of interest. These people seem like they're clearly, I think someone was using the product, as I recall.
well, if I can offer a few thoughts on that,
Let me ask you one other thing, if I can, please. On the deadlines, tell me what your view is. Can you hear me all right? Can you hear me okay? No, you can't. Can you?
excuse me, I could.
Can you all hear me?
I can hear you.
Yes, he's got hearing.
No, I understand.
Yeah.
Can you hear me?
I think so.
Okay, well, it says in the statute, I'm trying to figure out what you think their failing is. It says in the statute that the agency shall propose a rule not later than 1 year after the date on which the final risk evaluation regarding the chemical substance is published. So they got a year there. You have to have the final risk evaluation, and then you've got a year. And then it says they can publish in the Federal Register a final rule not later than 2 years after the date on which the final risk evaluation is published, and may extend the deadlines under this paragraph for not more than 2 years. You're talking about 1 year as if it's fixed and there's no confusion here. I'm not sure how you get there.
Yeah,
Why do you
no,
think, what are you citing that says a final rule has to be set? There are other provisions I could point you to as well.
Well,
Don't support your notion that if they don't act following 4F, you seem to be arguing following their determination under 4F, they've then got to produce a final rule within 1 year. I don't see it. Where is that?
well, we're not saying that they must issue a final rule.
Well, then tell me what you are saying.
Yeah, I think we're saying that they need to issue a proposed rule. And the rule that they issue needs to be based on the 2023 risk assessment, and per the terms of the statute, 6A of the statute, it needs to be a rule which eliminates the unreasonable risk. So those are the metes and bounds of the proposal.
They have to have notice of proposed rulemaking. Be precise. I'm not sure what you're saying. What are you saying? They have to have done, where did they fail?
Well,
Because it looks like they were trying to be very responsible. They
Well,
got thrown off by the Fifth Circuit's opinion.
I wouldn't
Let me
go that-
finish, counsel. They got thrown off by the Fifth Circuit's opinion. And so you have to put that in the equation. So they were doing what they were supposed to do. They answered the public petition that was filed by your folks. They answered it in a very responsible way. They said, yes, under 4F, we think there's something here. We've got to get going. Okay, now you got the Fifth Circuit interceding with what they had to say. I'm trying to understand, where are you looking in the statute? You keep saying 1 year. 1 year beginning when and why?
1 year beginning on December 1, 2023, when EPA made a formal determination of unreasonable risk. And the statute,
Doesn't
section
say that.
6.
So you're talking about 4F. It doesn't say that. That's not what 4F says.
No, but that's what
It says
section
take
C says.
appropriate.
But
Let me just tell you what my concern is so you can answer it, all right? 4F says take appropriate action or whatever those were. It doesn't say issue a final rule. It says take actions under 4, 5, and 6. Those actions can include risk determinations. They can conclude setting questions out to parties who have an interest to get their interests, et cetera. Then, once a risk determination has been made, then the rules click in about when a final rule has to be issued. And I'm not seeing where you're slotting this in. It is not off of 4F. 4F does not give you what you want. All of the following language in 4, 5, and 6 talk about risk determination, and they talk about the issuance of rules. 4F does not.
Well, Your Honor, I think there are two aspects of 4F that are important. First, there needs to be an applicable action, and it needs to be an action under Section 6. And so you look to Section 6 to see what options Congress has given the agency.
Risk determination. That's the first thing. That's very clear. You got to do a risk determination.
Well, but they've done that.
Okay, that's what I'm saying. But then the statute sets dates by reference to the risk determination, when that is done, when a rule can be issued, how much of an extension you can have in proposing the rule. I'm trying to figure out, what is your theory? They failed to do what on when?
Well, they had, first of all, they did not take an applicable action because information collection is nowhere mentioned in Section 6. And you need to look to
Section 6 refers to the APA. The APA in rulemaking procedures surely contemplates an
This has
agency.
nothing to do with the APA.
It does have, the statute refers to using APA procedures.
Well,
in developing
in
the
a very limited way. I think the statute has a detailed rulemaking provision of its own, which is very prescriptive. And
Okay.
it doesn't say anything about information collection. What it does say is that there is a mandatory duty to propose a rule within a year after a determination of unreasonable risk. So coming back to 4F, we would say, number one, information collection is not an applicable action under Section 6. And number two, we would say it is not an action which prevents or reduces the risk to a sufficient extent, which is the second directive in Section 4F. An information request is simply an information request. It doesn't prevent a risk. It doesn't reduce a risk. It certainly doesn't reduce the risk to a sufficient extent. So we would say on this basis, the information request did not meet the plain language of Section 4F. And we would further go on and say that the only, if you look at the rulemaking provisions of the statute, the only applicable action that the statute calls out is proposing a rule. It doesn't say you do information collection and then propose a rule. It says you propose a rule.
Got it. Got it. I think we got it.
You got it. Okay.
Yeah. All right.
Okay. Thank you, Your
We'll
Honor.
give you a little bit of time for rebuttal, and we will hear now from Mr. Anderson. It's the Anderson morning in court.
No relation. Good morning, Your Honors. May it please the court, Christopher Anderson for the EPA. I'll get to what I perceive to be the nub of the dispute here, Your Honor. Neither Section 4F nor Section C1 required the EPA to propose a rule within a year. Section 4F says only the EPA has to initiate applicable action under Sections 5, 6, or 7. EPA did that by requesting information that it needs to complete analyses that are required by Section 6 for rulemaking. And Section C1 doesn't require EPA to issue a rule within a year because Section C1 says the EPA must propose a rule within a year of making an unreasonable risk determination under Section B4. EPA has not made an unreasonable risk determination under Section B4. My friend is correct that
That has not been done?
that has not been done, Your Honor.
In what respect has it not? Because Section 6 requires action as soon as practicable, and it creates a string of consecutive deadlines to make sure that EPA regulates harmful chemicals in a timely manner. And what EPA has done so far is a request for comment in the Federal Register. Is EPA, in your view, currently obligated to meet any further deadline in Section 6? And if so, which deadlines and when?
Currently, we don't think EPA is obligated to meet any of the specific deadlines in Section 6.
Why?
Because those deadlines are triggered by a finding of unreasonable risk, which EPA hasn't yet made under that.
EPA has made a finding of unreasonable risk about this very process and byproduct.
So bear with me while I split
Yes,
a
in a different proceeding.
Right. So let me split a hair and bear with me. It is the same standard. Unreasonable risk is the same statutory language, but Section 6 requires that finding to be supported by different analyses, and it requires that it be made through different procedures. EPA is currently determining how much additional work it needs to do to translate the finding that it made in the Section 5 proceeding into a Section 6 unreasonable risk determination, and EPA hasn't made a determination in that regard at this time.
But even then, you would be under a deadline, no?
Yes, if EPA, well, I think if EPA made an unreasonable risk determination.
No, but you have an unreasonable risk determination, and you're telling you're in a process of gathering information, and isn't there a 3-year window? If you had no information at all, I'm looking at B4G.
B4G.
Complete a risk evaluation as soon as practicable, but not later than 3 years after the date on which you initiated the risk evaluation. So you're saying you haven't even initiated a risk evaluation?
So that's an interesting question, Your Honor, that I don't have a firm position on for you today.
That is not an adequate response. I'm sorry.
As Your Honor observed, let me explain. And I do appreciate your frustration with this. And EPA has some frustration with this. The statute.
I can imagine.
The statute doesn't clearly lay out how EPA proceeds in this unusual factual circumstance where it's not conducting a Section 6 proceeding through the ordinary process that begins with risk prioritization. Instead, it's starting one from a Section 4F proceeding and from the granting of a Section 21 petition. And it has previously done this Section 5 process. So if EPA had granted a petition, the plaintiff's petition for a Section 6 proceeding without the previous Section 5 process, I don't think there's any question that EPA would have to commence a brand new risk evaluation and proceed with the procedures as they're laid out in the statute. In this case, I think EPA would ideally like to be able to do something less than all of those procedures that still meet the requirements of Section 6 that relies on the Section 5 process. But the statute doesn't say how EPA can do that. And EPA is undertaking an analysis of how it can translate that Section 5 finding, what additional work it may have to do to reach a Section 6 finding of unreasonable risk.
Your foundational argument is you can't be in the rulemaking part of 6 yet because you have not done a required risk evaluation.
That's correct, Your Honor.
I mean, that's the heart of what your argument is.
Yes.
Which really immediately rebuts the claims that are being made here. You can't get to the rulemaking part of 6 and all of what it says because that all relies on the assumption that risk evaluation has been done.
Correct, Your Honor.
And risk evaluation is, as I understand it, as a layperson, is not a small procedure.
It is not a small procedure, Your Honor. It has several steps. It typically takes years. I do want to say, and we put this in our brief, the fact that EPA doesn't think it currently has a date certain deadline under Section 6 doesn't mean that EPA is free to take all the time in the world that it wants.
That's the thing. I mean, why shouldn't we, for example, and I'm not speaking even for myself, let alone for my colleagues, but just as a hypothetical, send it back to the district court to work with the parties to come up with a deadline for this, as you say, trying to kind of dovetail or translate the information that EPA has with its forward moving duties under Section 6. I mean, the Section 6 risk evaluation is to come up with a determination whether the chemical substance presents an unreasonable risk of injury to health of the environment. EPA has made that very determination. You know that this manufacturing process produces an unreasonable risk of injury to health of the environment. And that's a big part of the work. And I understand that there's a few other aspects, but it seems unlikely that the statute would afford you no deadlines. I can't read the statute to say just because of this, as you say, unusual circumstance, you are off the grid altogether.
I think the statute doesn't contemplate this specific situation. I think that the statute doesn't set specific deadlines, but I think would potentially be applicable is in some other suit, not a non-discretionary duty suit, but in an unreasonable delay suit. Certainly a court could look at the statutory deadlines and use those as benchmarks by which to judge whether the agency is being dilatory.
So the burden is on members of the public. The burden is not on the agency at this point.
I mean, the agency always takes its responsibilities to protect human health and the environment very seriously. The question is, what can a court order the agency to do, and what did Congress say that was the appropriate relief in a citizen suit?
Would you at least agree that the agency has forward-moving duties under Section 6?
Absolutely. When for two reasons.
Wait, explain what you mean when you say yes, and then you can give the two reasons. I thought you told me you didn't think it had any particular deadlines.
EPA has a duty to conclude the Section 6 proceeding within a reasonable time. It has that duty for two reasons. It has that duty because it granted the plaintiff's Section 21 petition, and also because it has opened a docket and said that it is committed to pursuing a rulemaking process. EPA believes it is bound to complete that process within a reasonable time, but you don't need to take EPA's word for it. The Ninth Circuit held that very thing in a case in Ray Community Voice, and let me get the citation for you.
Not under Tosca.
Yes, under Tosca. That was 878 F3rd 779. That's the Ninth Circuit. And EPA does not contest that it now has a duty to complete the proceeding and to complete it within a reasonable time.
And so that's just a reasonable time.
It's just a reasonable time, yes.
How much can be carried over from what you did that turns out to be only of minimal use that was tangled up with the Fifth Circuit?
So I think anything that's scientific can be carried over. All of the science that EPA did in the risk evaluation. Section 6 requires EPA to consider a broader range of scenarios. There might be some additional science that needs to be done. EPA's regulations ordinarily require a Section 6 risk evaluation to go through peer review, which the Section 5 risk assessment did not. So perhaps EPA will determine that it needs to do that. Those are the types of issues that EPA is working out and has not yet made a determination on.
Right.
Tell me what else and where to look in the statute when you say it's different, because Mr. Sussman was saying that, the risk evaluation is just unreasonable risk, don't consider cost or other non-risk factors, and examine exposed or susceptible subpopulations, period, end of story.
So a Section 5 risk assessment is specifically for the new use for which the new use notice is made.
Isn't this rulemaking, though, about this process, which is the thing that produces the PFAS? And this is the only U.S. participant in engaging in that process? So I'm just saying the
Right.
rule is not really substantially broader than the new use,
You're going to be angry with me, Your Honor,
Been
but
there,
I have to be
there.
honest. EPA has not made that determination yet, and that's because ordinarily EPA would not undertake a Section 6 rulemaking for a specific condition of use, and so in this case, EPA. And EPA currently has a rulemaking out right now about the range of scenarios that need to be taken into account in a Section 6 risk evaluation. That's a proposed rule, not a final rule.
Are you going to wait until that's completed to proceed here?
I have not asked EPA that question, but I don't think so. EPA is proceeding with this.
So when you
process.
talk about that, I mean, I'm looking, for example, at the risk evaluation subsection B here under Section 6. Are there provisions I should be looking at to inform what you think you have to do under Section 6 that you did not have to do under Section 5 that can just help us get a grip on
Sure. So
what the task is that you believe that the EPA is engaged in?
yeah. So Section 6 speaks in terms of needing to evaluate the conditions multiple of use of the substance. And so that's the issue that I was just speaking about, whether it needed to be broader. But I would also point your honor to EPA's regulations at 40 CFR Part 702 Subpart B. Those are the regulations.
Say it again. I'm sure it's in your brief, but 40 CFR?
Part 702 Subpart B. Those are the regulations that govern risk evaluations under Section 6. EPA is bound by those regulations. They provide a number of detailed steps that the agency has to undertake when preparing it. And the other two things that I would point out is those regulations ordinarily require a Section 6 risk evaluation to undergo peer review. And TSCA itself, Section 6, requires that a Section 6 risk evaluation be published for public comment, which hasn't happened in this case.
Right. And I think that's why there's a year that gives you to do the rule after the...
After EPA makes the finding, which I think happens after the risk evaluation has gone for public comment, and then EPA makes the action.
There's a 4F finding that's been made.
But the 4F,
And then there's the Section 6 finding.
Right.
4F is just your agreeing that there may be a risk here. That's all.
That's correct. We just agree that there may be information.
That's not about rulemaking. You haven't gotten there yet.
And just so that I'm perfectly clear, and I don't think it matters for this, we agree that the plaintiffs have alleged that there may be information. So on this procedural posture, we don't contest that point, but we haven't actually made that finding.
You're talking about the Section 6B4A finding.
The Section 4F finding. 4F.
Doesn't your letter pretty much say?
I think probably, I just want to make sure that I'm clear and not saying the EPA has said things that they haven't. What EPA did when it granted the Section 21 petition, I think is essentially fine to the same thing, but it is.
It was like, at least to me, it was like you were looking at 4F and, okay, there's a petition. Okay, they're right. We should do something.
Yes, that's correct. And
it was made with respect to this process as the predicate to the new use petition, the new use order.
No.
So EPA didn't need to make a 4F finding to initiate the Section 5 process.
And the Fifth Circuit in that letter, there's a footnote excluding saying this isn't, you're not dealing with the Fifth Circuit problem.
Correct. I appreciate that this is all very complicated, and TSCA is the overlapping nature of TSCA makes this more complicated. But I think getting back to what this suit is about, a non-discretionary duty suit under Section 4F, EPA has initiated a proceeding under Section 6. EPA believes it is obligated legally to conclude that proceeding within a reasonable time, and we think that the district court could award no more relief. And for that reason, we think the district court was correct in holding that the case is moot.
All right.
Why can't the district court consider with the parties if we remanded it? What would be within the realm of reasonableness, given that your inquiry under risk determination under 5 and 6 are different?
So I think under this court's precedent in Sierra Club v. Thomas, anything that involves EPA's discretion needs to happen in an unreasonable delay suit, which is brought in this court in the first instance and not the district court.
Okay.
Thank you, Your Honors. We would ask that the district court be affirmed.
All right.
Thank you. Now we'll hear from Ms. Ellsworth.
Good morning, Your Honors. Jessica Ellsworth on behalf of the intervener Enhanced Technologies. The district court was correct here that count 1 of this complaint is moot and count 2 is outside the limited waiver of sovereign immunity in the citizen suit petition. It could also have held the plaintiffs lack standing. Each of these are reasons to affirm. I think there is 2 misunderstandings I want to clear up from some of the discussion that's been happening so far. And the first is that the Section 5 finding that underlay the Section 5 orders has been vacated. So when your honors are asking questions about can't they just transfer it over, that has been vacated. So there is work that would need to be done in that. Second, and relatedly, the Section 6 risk assessment process is very different from what happened under Section 5. And you can see this spelled out in Section 6B, which is conveniently not included in the appellant's addendum, but is in the government. It sets out the process. And among other things, the process differs because it requires first a draft of the risk evaluation, then an opportunity for notice and comment, and then a final publication. And that means that if there are errors that are made, among other things, it gives a company like Enhance an opportunity to weigh in on the draft risk assessment and correct some of those or provide information as to the agency before it finalizes it. As the government counsel pointed out, 40 CFR Part 702 sets out very specific and detailed requirements for a Section 6 risk assessment. And one of the things I think is important to keep in mind is that Section 5, we're supposed to be talking about something that is a new use, a new chemical. There is a different analysis when what you have is an existing use. And here the fluorination process has been used back to the early 1980s. So you're talking about a different set of factors that go into it. And before you can get to the proposed rule, which is even farther down the line, there are an additional set of factors that come in related to alternatives, related to cost benefit analysis, related to impact on the national economy, related to all of the positives that come from fluorinating containers. The reason fluorination is used is to keep the toxic material in those containers inside it. There are actually a lot of reasons under the Clean Air Act and other reasons that it's very good to use fluorination to improve the barrier properties of the product. So all of these, I think, flow in favor of the fact that under 4F, the agency did everything it was supposed to do when it said we're going to start looking at this. It now has a period of time to follow the rules set out in Section 6B, 6A, 6B, 6C before it could get any further along. So for all of those reasons, we think the district court was exactly right that count 1 is moot. I'm happy to address standing or any other questions that your honors have on the Section 4F, Section 6, Section 7 questions.
Nope.
If there are no other questions, then we also ask that you affirm the decision below. Thank you.
So I want to come back to a very fundamental point here, which is that EPA has been very clear that there are multiple paths that lead to a Section 6 rulemaking. It's also been very clear that Section 6 can be triggered by a finding of unreasonable risk, even if the agency has not conducted a risk evaluation under Section 6B, which complies with all of the plethora of requirements that Government Counsel and Enhanced Counsel are describing. So,
What's your authority for that?
excuse me?
You say that they can, their obligation for a rulemaking under Section 6 can be triggered by a finding of unreasonable risk that doesn't meet the 6B
Yes,
criteria.
yes.
And I just was asking you, where are you finding?
Well, we cite that in our reply brief, and it's a decision that EPA made actually on a Section 21 petition in 2023. And they were very explicit there that even though a risk evaluation had not been conducted, the evidence amounted to a demonstration of unreasonable risk, and therefore enabled the EPA and authorized EPA and directed EPA to go right to rulemaking without backing up and conducting the full risk evaluation. And there's a court decision in the Northern District of California, which we also cite, which says basically the same thing, although the facts are slightly different. And what it says is that granting a petition for rulemaking under Section 21 leads directly into the Section 6 rulemaking process. It does not require that the agency go back and conduct a risk evaluation under Section 6B. So I've been focusing on Section 6C, but I also want to direct you to Section 6A, which in a way is the heart of the rulemaking process under Section 6. And Section 6A basically says the same thing. It says that if EPA has determined an unreasonable risk in accordance with Section B4A, then the agency shall conduct rulemaking to address the risk. And it goes on and says that the rulemaking must eliminate the unreasonable risk which has been found.
All right. Thank you very much. Thank you.
Okay, thank you very much.
The case is submitted.
This is the report of the Monday,